and welcome to another InventRight.com TV show. My name is Andrew Krause. I co-founded InventRight with Stephen Key over 18 years ago and been coaching and mentoring inventors ever since. What I want to talk about on this video is basic licensing terms. We're not going to go into advanced terms, but basic licensing terms. The first thing I'm going to talk about is who are the players here. And there's basically two major players. There's the licensor and there's the licensee. And people, when they're new to licensing, get a little confused on this. So the licensor is basically the inventor or the product developer that's going to rent or lease their product to a big company. So that big company is the licensee. So the company that's going to manufacture and sell the product and distribute it, do all that, they're the licensee. And then the inventor is the licensor. Okay, so that now you know those two players. People get confused in that. Write it down because it takes you a little while to get used to it. A licensing agreement is the agreement between the inventor, the licensor, and the company, the licensee. And it's an agreement that they will pay you certain, there's a lot of terms. There's another video I did on licensing agreements. You can check that out. But there's a lot of terms in a licensing agreement, and of course the major one being that they need to pay you a royalty for every unit that they sell. Usually that happens quarterly. And they can't just sit on it. So if a good licensing agreement will have performance guarantees in there that make sure that they can't just sit on it. So some basic terms: a licensing agreement is the agreement between an inventor, the licensor, and the company, the licensee, to pay the inventor royalties every time they sell a unit on usually a quarterly basis. So and then the licensee is obviously responsible for the money and the workforce and the tapping into their existing distribution and selling the product. I'm going to talk about a few patent terms now. When people are new, they get confused on this. There's a provisional patent application which gives you a year to say patent pending to see if there's any interest. And you can file one on your own in common English, and it's only $70. So we refer to that as a PPA, a provisional patent application. So that's what a PPA is. It's just short for provisional patent application. What's the big benefit? Allows you to say patent pending for a year, see if there's interest. If there isn't any, you're only out $70. You're not out 8 or 10 or 12 grand for a patent. Okay. Now, then there's two types of regular patents that aren't temporary placeholders like a provisional patent is. There's a utility patent, which, and again, attorneys, don't beat me up on this. I'm just trying to keep this really simple, the basics on this. So there's a utility patent, which is the way something functions. Well, and usually you're patenting a little piece of it. Like, well, there's this hinge here and it offers this functionality. There's this button here, it offers this functionality. So that's a utility patent. It offers some sort of functionality. The other type of patent is a design patent, which is just the way something looks. It's literally just a drawing. You don't have all these words explaining what you're protecting. It's literally just a drawing, and it's a look. So if you change that look a certain amount, you can get it right around a design patent. There are instances where they're useful, but 99% of the time, you guys are going to be filing a utility patent. Now, you don't want to do that until you get interest using the InventRight approach. You see if there's interest with the provisional, and then if there is, the technique that we teach our students is you get the company to pay for the patent. You give that money to attorney, your attorney references the provisional. So you're preserving that protection date. So one thing that people get confused on is provisional and non-provisional. So people are using provisionals so often these days, PPAs, provisional patent applications. People will refer to a utility patent, which is what most of you are going to eventually get if you sell your idea, as a non-provisional. It's like saying it's not this. It's kind of weird wording, right? So a provisional patent, temporary placeholder for a year. A utility patent is a full patent that's going to go for 20 years, right? But a lot of people refer to a utility patent as a non-provisional. So you got a provisional and a non-provisional. Whenever they say non-provisional, they're talking about a utility patent. There is no provisional patent for design patents. So we covered what is a licensing agreement. It's an agreement between the licensor and the licensee. The inventor is the licensor. The company is the licensee. That you will pay me royalties every time you sell a unit, and usually on a quarterly basis. And obviously there's a lot more to a licensing agreement than that, but that's the basics. And then you got the licensor, the inventor, the licensee, the company. Provisional patent application lets you say patent pending for a year. It's only $70. It's what we highly advise all our students to do. And then you have utility patent, which is protecting some functionality about the product. And you have a design patent that is protecting the way something looks, not the way something functions, which most of you will never file one of those. It's very unusual. You also have something called a plant patent, which is for plants, which I've literally never had an inventor that was patenting a plant. When I say plant, I mean literally something that grows, and that's separate. I never looked into those. To be honest, I don't know anything about plant patents. In 18 years, I've never had a student working on a plant patent. That's more for scientists. So hopefully those basic terms and going over them were very helpful. When people are new to licensing, we start a little bit more advanced sometimes. We use all these terms and people don't know what they are necessarily, so you're sitting there wondering, watching a lot of videos. So I want to do a video on just some really basic terms that we refer to quite often in licensing. So for those of you that are new, you'd find it really helpful, because I know a lot of you are new to our YouTube show and you're watching this. We have people that say they binge watch the show for 5 or 6 hours. I hear that all the time, and that's really cool. Thank you guys. It's the greatest compliment you could pay us. So I want to remind everybody to take care, keep inventing, and we'll catch up with you next time. See ya. Bye.
Hi, this is Stephen Key, and I just want to thank you for watching InventRight TV. We're here to save you time, save you money, and show you how you can bring your products to market through licensing. So please subscribe down below, click on the button, and tell your friends. Thank you.